Thank you, Laura. Thank you for inviting me to be with everybody here tonight. I want to also thank Laura's staff, particularly Linda, who helped put these slides together, and everybody else who kind of set this evening up and got the room all ready and the treats and everything. So, and thank you to you all for coming. The goal for tonight is not for me to just lecture. Hopefully it is for you to get questions answered that you might have as it relates to what do I do when someone in my family dies? How do I prepare for that? And maybe we'll get into a little bit of the estate planning process too, because it's hard to separate out probate and the estate administration from some of the planning items that go along with that, or even after somebody has passed away. So I would encourage you, we do have a small group, as Laura said. So if you have questions as we go along, please feel free to answer them. I think we have about an hour of time, and we can reserve some time at the end too for questions and answers. But it seems like it's a lot more fun and a little bit more interesting if I'm not just doing all the talking, but you guys have questions that are on your mind, and I can possibly answer some of those for you. So. As Laura mentioned, on your, in front of you on the desk, there is this checklist that we put together, which I'm not going to go through all of the items on this checklist, but I do want to point out some of these things in each of these categories, and we'll go through those. What I would say about this whole topic is that this is much easier. This process is a lot easier when there's been communication up front. So it doesn't necessarily mean that you have to divulge to everyone in your family how your estate is going to go and who's going to get what. But you should, at a minimum, let people know what you do have in place. Do you have a will? Do you have a trust? Where are those documents? Where are your passwords? Your accounts? Where are the records that are going to be important in this process as we work through assets and transferring and transitioning assets to beneficiaries? Another really vital important piece is, who are your advisors? Because that's really who the family's going to reach out to. People like Laura and her staff. If they know you're working with somebody, these folks are going to be an immense treasure of help and assistance to family members that are put in a position of having to deal with the estate and the administration of the estate. So I just think communication is really a vital thing. I know that I think Laura, probably in your practice, family meetings, maybe having meetings with not only the client but other members of the family. We do that as well. Just sitting down with families and saying, okay, here's what's in place, here's who's named in what roles, maybe here's who's going to be the personal representative, here's who's going to be a trustee. That's helpful because people they kind of have to understand what they're getting into when they are being appointed to take on those kinds of roles. The other thing that's important is sometimes I get families that say, well, I have 3 children and I don't want to have to pick one of them to be my executor or my personal representative. I want to name all 3 of them. That can be good and it can be bad. I would say the majority of the time, it doesn't work out quite as well as you think it does. And most of the time, people are saying, I want all 3 of them to serve in this capacity because they don't want anybody to feel bad. They just don't want us to feel like I'm playing favorites, or I'm choosing somebody over somebody else. But a lot of times, if you talk through the role and what this person is going to be responsible for doing, it makes it a lot easier to have communications with other family members as to why somebody might be named as the first personal representative or executor, and if they can't serve, maybe then you've got a successor or a successor to that person. Particularly if you have people who are out of state or out of the country. That can pose a lot of just logistical and practical issues. So those are things too to keep in mind as you're thinking about communication and the kinds of issues, the kinds of topics that you might want to communicate to family members that are going to be involved in this whole process. So this checklist is designed to help you kind of with the orderly distribution. It's set out in some legal terms and some not so legal terms. In fact, I would say most of this checklist is not really legal. It's more of just things that you need to do and when you should do them. So as we look at kind of some general items, this first category of items, these are pretty obvious, but sometimes in the emotional distress of a death, of somebody's passing, some of these things are the last things that people think of. And sometimes it's helpful to take a family and say, okay, you're going to be responsible for these things, this person's going to be responsible for these items, and it just helps to kind of cover all the bases. So I'm not going to go through each of these, but I would emphasize a couple of these. First of all, I think it's important to this second item here, canceling unnecessary home services, newspaper deliveries, cable service, mail, that's down here in the list. And the reason that's important is because, believe it or not, there are people in the identity fraud crisis that we have and in this environment, they actually troll obituaries. And they're looking for things like people who have passed away, but there may be credit card offers that are still coming to their address, or there may be things in their mail that haven't gotten turned off, or there may be service providers. So it's important to kind of secure the residence, secure the things in the residence, and then to alert those kinds of delivery services, service providers that this person has passed away. Forward the mail to someone who can then be collecting the mail, going through it, making sure that if there are bills or invoices or other things, medical claims, whatever it might be, that those are kind of being gathered and someone is being responsible for making sure that all of that is getting collected. Fourth bullet point down deals with certified death certificates. Whether you have a probate or not, and we'll talk about that. We'll talk about this probate process and what's involved in the probate process. But even if you don't have a probate, if you've got assets that are going to pass via beneficiary designation, or maybe they're held in joint tenancy, so they're going to pass to a surviving joint tenant. We'll talk a little bit about ownership. But you're going to need a fair number of certified death certificates, because even those kinds of assets are going to require some notice to the institutional provider or somebody hanging onto those accounts that somebody has passed away. So it's a good idea to get about a half a dozen at a minimum. Funeral directors are very good at helping families get those, and they can usually be turned around quite quickly, which then enables you to kind of help with the transferring of the assets, which we'll talk about. Gathering important documents, this is huge. Knowing, if you know, whether there's a last will or testament or trust agreements, that's terrific. If you know where those documents are, that's even better, because then you can get your hands on those. But things like birth certificates, marriage licenses, social security cards, those are all important documents as well that you want to gather. You figure out where those are, whether they're in a safe, whether they're in a file, whether they're in a safe deposit box. There could be a lot of places, but it's good to know, where are those documents held, and I need to get my hands on those. Titles to assets are also important, and we'll talk about that as it relates to real estate as we move forward with some of these topics. A couple other things on here just to point out. Towards the bottom of the page, there's a couple of interesting ones that most people don't really think about. One is notifying the registrar of voters of a decedent's death. Probably not really thought of. But again, that's another way that people can use your identity. So letting them know, making sure that they've got that information, it's a good idea. The credit reporting agencies. This is where if somebody's gonna take your identity and they're gonna try and open credit in your name after you've passed away, or somebody in your family has passed away, you need to notify those credit agencies that this person has passed away and that anybody seeking to get credit in that person's name is not doing it legally. So on the back of the checklist, we do have some of the contact information for the 3 credit bureaus, Equifax, TransUnion, and Experian. And it used to be where you could contact one of the credit agencies and the other 2 would let the other, or that one would let the other 2 know. I'm not so certain that's the way it is anymore, so I think it's a good idea to at least reach out to each of those credit reporting agencies. Did you have a question?
I do.
Yeah.
I would like to get my name removed from mailing and marketing lists right now.
Yes, yes, yeah.
And how can that happen?
Yeah.
It seems like you get more and more and more.
Yeah, and we are, my mother-in-law passed away last year, and we're still getting mail, despite having
Sure.
written to these folks and saying, she is deceased, please don't send any more, mail. It's difficult to do. Now, there are a couple of, I think.
Did you put them in here?
I think we might have put the website in here. I don't know if we did or not. ARP is a good resource. That's in the back, the last page.
Yeah.
But there's also there is a direct marketing website. If you do a search on it, you can Google it, and it's an opt-out type of agency where you let them know, I don't want any direct marketing. Take me out of any direct mail. That's not gonna guarantee that you're not gonna get it though. So the next best thing is to send where you're getting those letters from, return to sender. You can just send it back, return to sender, just write it on the envelope, return to sender, no longer want any mail like this. Or you can call them or send them a letter and say, please take me off your mailing list. I don't want to receive any more unsolicited offers or any other mail, from you. It's not that easy to do, but
It isn't.
yeah.
Because I thought I had done all this. I haven't done the return to sender.
Try that and see if that works. If they start getting things back that they paid for postage where it's just coming back, at some point they may take you off the list. Part of the problem is that once you get on one list, they tend to sell your name or give your name to other lists. And that's usually how people get kind of inundated with all kinds of solicitations and stuff. Any other questions? Okay, if not, let's turn to the second page and we'll talk a little bit about assets. These are, again, pretty obvious here. You want to know about life insurance, annuity contracts, pension statements, retirement accounts, bank statements, tax returns, the last 3 to 4 years of tax returns. That has a lot of information on it. It's very helpful in terms of identifying assets or income and where income is being produced, and it can help just make sure that you are gathering all the assets that this person might have had. The one thing I'll say about real estate, it is best if you can find the deeds, copies of deeds with which people have taken title, whether it be to a home or to a cabin or to another piece of property. The actual deed with which you took title is the best evidence of how that property is owned. Some people will provide tax statements, and that'll have some information on it, but it's not going to actually have the exact names of how the title is held and the type of ownership. So I've had people come in and say, well, I know my father just died and they had a lake home, they had a residence and they had a lake home, and I know both pieces of property were in joint tenancy. And I will ask, do you have copies of the deeds with which they took title to the property when they bought it? And sometimes they can find them and sometimes they can't. If you can't, it's not like it's the end of the world. What we do then is we do a search of the county recorder, and then we get a copy of the deed that's on file. But a lot of times what happens is once you get the deed, you realize that property was not held in joint tenancy. It was held in one person's name. Or maybe it was held in both of their names, but it was held as tenants in common, which is a little bit of a different kind of ownership than joint tenancy. Joint tenancy with right of survivorship, one person dies, property passes automatically to the surviving joint tenant. If it's in tenants in common, that's a different situation. You've got a half interest that each individual owns. So that can be different. So it is important to see either the copies of the deeds, or again, we can go to the county recorder, but it's important to know how title is held on real estate. And then titles to cars, trucks, boats, trailers. I'll talk a little bit about how we can transfer vehicles now. This is a relatively new law in Minnesota. When we get to transferring assets, we'll talk a little bit about how the transfer of those kinds of vehicles works right now. Okay, any questions on the assets? Assets to be collected. You're gonna have to do some investigative work unless your family member was working with a terrific financial person who, like Laura and her staff, who put together a full balance sheet for you. Because that's one of the things that is incredibly helpful, is if you can come in and say, you know, here's a balance sheet that my family member's financial advisor was working off of. And normally, even if they're not managing every single aspect of the financial life, that balance sheet's gonna have all the assets on it, and that's gonna be very helpful. And a lot of times it'll even have the ownership on it. It'll say, yep, this was a joint account, or no, this was just an asset or an account that was in just this person's name. So that can be very, very helpful to have something like that to refer to. Okay, moving on to liabilities. There's a list here on the checklist. Again, things that you're gonna have to look for. Mail is gonna be important because you'll get invoices, bills, or anything else that might be coming. Credit card statements, any kind of medical health related bills, any kind of claims, any kind of paperwork, that should all be kept, just gathered. Just put it in a pile so we can make a determination as to what do we need to save, what do we need to respond to, what can we just simply shred or toss. Advise all known creditors in writing of the person's passing, but don't pay the bills. People get into this a lot where it's, well, I paid a whole bunch of bills, and I said, well, what money did you use? Well, I used it out of my own checking account, or I used it out of a joint account. The problem with that is, and I know people want to take care of those liabilities. They want to take care of those right away. The issue that you get into, though, is in Minnesota, we have a creditor priority. So if you're paying bills and all of a sudden now there's not enough assets to pay all the claims that might be made against that estate, you may be at issue, or you may be in trouble for paying bills that you paid out of priority. There are certain claims that have priority over others. And so what I tell people is, yeah, you're gonna get calls and they're gonna say, when can you pay the bill? And what you need to tell them is that we are assessing the estate, and as part of the administration, we will be assessing priority of the claims, priority of the bills, and getting those paid. But you don't have to do it right away. And in fact, it's probably not a good idea to do it right away, because if you pay claims out of priority, that can mess you up if you're the personal representative or the executor or the person that's going to be in charge of kind of handling the estate. So, does that make sense? Okay. And then the other thing that I think is important as it relates to liabilities is to set up an estate account that you can kind of use as a repository for monies coming in, and as an account for bills being paid. Now, if you haven't been appointed as the executor or the personal representative, you're not going to be able to set up an estate account. So that's going to have to wait until you can actually be appointed. So if that's the case, what I say is just put it into an account where you are accounting for it, and eventually you can move those monies into the estate account. Because if you are the personal representative, or you are the executor, or you are the person that's going to be responsible for handling the administration of the estate, you also are responsible for doing an accounting. It doesn't have to be a formal accounting, but if a beneficiary comes or a creditor comes and says, hey, time out, where'd the money go? What came in, what went out? You do need to be detailed enough to be able to say that, okay, here's date of death. Everything from this point going forward came into the account, and anything that we paid came out. And you can account for all of that, because eventually that's gonna have to be part of what's called a final account that you may or may not have to file with the court, but you do have to keep it if the beneficiaries ask you, or if a creditor claim appears and the creditors wanna know where did the money go. So that's an important thing.
I have
Yes.
another question.
Yes, good. Yes.
This young man is my personal representative,
Mhm.
and I have put him on my checking account at the bank. Was that a good idea or not such a good idea?
Yep, so a couple things. When you put him on as someone on the account, is he a joint owner of the account, or is he just on as a convenience?
Well, I just wondered are you getting statements? You're not getting statements.
No.
Okay, so he's probably on there as a convenience,
And he is a convenience.
which
No
means
question.
that you could. He's very convenient for you, right? That means that he can go ahead and sign checks, and if something were to happen to you, he would potentially have the ability to go ahead and continue to sign checks after that. Now, some banks, if it's just for convenience, they'll say, yep, that's fine, you can do that while the person is alive. But if they're not a joint owner, or if it's not an account that is payable on death to that person, once date of death hits, that's it, that account freezes. That account will freeze until the estate, until your son is actually appointed as the personal representative of your estate. Yep.
So I need to.
So no, I wouldn't do a thing. And
Wouldn't
the
you?
only thing you could do, the only thing that you could do would be to change it so that he's a joint owner with you on the account. And that has its own pros and cons to it.
Yeah. Especially
So,
when there are three brothers.
That's
yeah,
right. That's right.
yeah, yeah,
Yeah.
so I think you're
Leave it the way
fine.
it
I
is.
think you leave it exactly the way it is, because the convenience to
And
you.
that would be then, if I became incapacitated, he could take over with the
Exactly,
bill payment.
that's exactly right.
Okay.
Yeah,
Thank
yeah,
you.
yeah. Okay. Any other questions before we move on? We're gonna start talking about how to transfer assets in that process of moving assets from out of an estate, out of the decedent's name to the beneficiaries and other families, members' names. All right. Okay, so on this, again, referring to the checklist, I mentioned financial advisors, other people that the decedent may have been working with. Those are really good resources for you in terms of just knowing what's there and how it's owned, and any other information that you may need to help you in your duties as the executor or the personal representative. Jointly held assets. Bullet point number 2. You can retitle jointly held assets, and typically you can do that with 2 things. One is an affidavit of survivorship, just saying that we both owned this person passed away, here's a certified death certificate, that's the other piece of paper that you will need, indicating and proving that this person has now passed away, and here's an affidavit of survivorship where I am swearing on my affidavit that I am the rightful owner now, as the surviving joint owner, I'm the rightful person to own this particular account. And this happens a lot with bank accounts, sometimes with investment accounts, houses, particularly between spouses. You can, if there was a house that was not in joint tenancy, it's in one spouse's name, that spouse has now passed away, you can actually move that house with an affidavit of survivorship and a certified death certificate to the surviving spouse. You cannot move it to other people in the family unless it's titled differently or if there's other things. But with a surviving spouse, you can move it with an affidavit of survivorship and a death certificate. So fairly straightforward. There are certain things that move by operation of law. things like retirement accounts, life insurance, annuities, assets that have direct beneficiary designations on them. So those, again, you probably get some paperwork from the life insurance company or the institution holding the retirement account. You have to fill that out to say, here's the beneficiary designation, I am the rightful beneficiary, and that will move to you just via operation of law through that beneficiary designation. You don't have to have the will. You may have to have a certified copy of the death certificate again. And they may have their own claim form that they want you to fill out, that you might have to do some paperwork for that. But otherwise, those assets will move directly to the beneficiaries listed on that account. And that can trip up people sometimes when it comes to their estate planning. Because sometimes people will come in and they'll say, I want my estate to be equally distributed among my 3 kids. But they have a life insurance policy that's payable to 1, or they have a retirement account that's payable to 1 or 2. And either those accounts just didn't get updated, they didn't get reviewed and updated, or maybe they were thinking, okay, if I give the life insurance proceeds to this kid and the retirement proceeds to this kid, there's a lot of different ways. People think, that'll avoid having a will. And in reality, it can pose a lot more problems than having had a document that just says, I give everything equally, or listing all 3 of the kids on the beneficiary designation form so that it will go to all 3 of them equally. And we'll talk about issues with that, but that's certainly one way to do that, to get that asset to your beneficiaries. You will need to know who prepared the decedent's taxes. Sometimes if it's a DIY person, they've kind of done it themselves, that's just fine, but you will need to file a final individual income tax return for the decedent. There may or may not be other returns that have to be filed, depending on size of the estate, whether there's a trust involved. The situation will drive what else needs to be filed, but for sure there will need to be a final individual income tax return filed. And then if the decedent had a will, if they actually had a will or a revocable trust, but some document that said, upon my death, this is where my assets go, and this is who I'm going to appoint to be responsible for making sure that my assets go to these people. If they have either one of those, there may or may not be a probate that is required. Part of it is going to depend on the assets and how they are held. Part of it is going to depend on whether it's a will or whether it's a revocable trust. Because revocable trusts can sometimes avoid that estate administration process, whereas a will, if there are assets that have to be transferred to beneficiaries, usually that's done through the probate process. We'll talk a little bit more about how that process works. But that person that you name as the executor and the personal representative is a really important person. It's somebody that needs to take the job seriously. They need to probably have some attention to detail. They need to be fairly organized. And they probably have to be, they don't have to get along with everybody in the family, but they have to be willing to do the communication with other people in the family. Because there may be other people in the family that are kind of like, hey, what is going on? And I can tell you that there may be nothing going on. But if you don't relay what's happening, people start to get suspicious. And we get so many calls from a family member who says, my brother was named as the executor and I haven't heard what's going on for over 6 months. Can you get involved and figure out what's going on? And a lot of times it's, no, I'll help you craft an email or some kind of a correspondence to your brother. It's a matter of him letting you know what's happening. Usually it's not something under the rug or anything like that. But when there's no communication and nobody knows what's going on, they start to get suspicious. So it should be somebody that can at least have a good sense of communication with the other family members or the other people that are named in the will or in the trust and are going to be devisees, people receiving assets from the estate.